Today's topic will be post-foreclosure strategies and understanding your rights. Homeownership is a lifelong dream for so many, and homeowners will go to great lengths to protect and preserve their investment. For most people, purchasing a property is the largest financial investment they will make in their lives. When a homeowner, in fact, falls behind on their payments, most lenders will review their borrower's financial information in order to determine if there's a sustainable solution for them to remain in the home. Unfortunately, as with all things go, a few will in fact not be able to afford a modified or a reduced payment for a long period of time, and a foreclosure of their property is inevitable. As we begin to go through the process or the topic of post-foreclosure strategies, certain questions may arise. If you do have the opportunity or the ability to ask a question, please go ahead and place it in the chat box. So my name is Samuel Luquin. I do work with the County of Los Angeles, the Department of Consumer and Business Affairs. Our mission here is to promote a fair and vibrant marketplace. Our department does serve consumers and businesses and communities through education, advocacy, and complaint resolution. The department has been serving the community since the year 1976. If you do need to contact us, you can reach us directly by email at homehelp@dcba.lacounty.gov. You can visit our website for additional information at dcba.lacounty.gov, or you can call us directly at 833-238-4450. Now, beginning with the idea of the foreclosure process, there's a lot of misconception about what foreclosure actually is. Excuse me, let me adjust this really quick. And one of the biggest things where an individual does face foreclosure, especially in the state of California, considering how quick the process is, and we will go into that in a second, is dealing with misinformation. Now, what is foreclosure? Now, foreclosure is not, it's not really a state, or it's not really, something that happens overnight. It's a process. And foreclosure is, by definition, the legal process that's used by a lender to recover the balance of a loan when a property owner fails to meet the obligations of their loan. Now, most commonly, an obligation of the loan that is failed to be met is the lack of payment. But as we go through this a little more, you can kind of see that there are other ways for a person to fall into foreclosure. Now, in California, there are two types of foreclosures, the first being judicial, the second being non-judicial. Now, a judicial foreclosure is going to involve a borrower and a lender, two parties. Now, if a lender does decide that they need to go after the balance of a loan, because as mentioned before, they're going to have to go to court and sue in order to get the right to foreclose based on the mortgage. Now, a non-judicial foreclosure is going to involve what's called a deed of trust. Now, the deed of trust is going to involve a borrower, a lender, and a trustee. Now, the difference is, instead of a lender being required to go to court to recover the balance of the loan, the borrower initially will convey over what's called the power to sell to a third party, which is called the trustee. Now, when this borrower does in fact default, or if they do in fact default on a loan, the lender will request from the trustee to begin the foreclosure proceedings. Now, the foreclosure trustee will conduct a public auction, essentially without without court proceedings, and they don't have to go to court or get the permission from a judge. Next slide. Now, here we do have a high-level overview of the California foreclosure process. What the foreclosure process actually does begin is with the notice of default. Again, this is the beginning of the process. It's the first notice that's going to be recorded with the county recorder's office for which the property within the recorder's office that the property is located in. 90 days after that, the document does indicate that the next portion of the foreclosure process will take place, which is called the notice of trustee sale. Now, that document does in fact, and we're going to go back and kind of look at the similarities and what the important pieces of information that are contained within both of them, but that one is going to be recorded 3 months after nothing is done, after the notice of default is recorded, or 90 days. Now, the next step that the notice of trustee sale will, or the next portion of the process that'll take place is the actual auction. Now, like mentioned before, the notice of trustee sale will set an auction date that will essentially let the public know that the property will be sold for a minimum bid, and if higher bids do come in, they will be taken as as the auction goes on. Now, 4 outcomes are typically going to happen when the auction takes place. The very first one would be the auction is postponed. So it's very possible that a property owner comes to their lender and maybe they file, some sort of request to have the property postponed, or maybe they come to some sort of other agreement, and the sale is just put, off for a short while. Another option is going to be that the auction does take place, and maybe a third party does not bid on the property. In that case, the property would, by default, be sold back to the lender. Okay. In this situation, a lot of the terms that are used or that people are familiar with is called REO, or real estate owned, and that's really where that situation comes in. The third opportunity for this property to be sold would be if the property is sold to a third party. And it could be that, some other individual comes and places a bid against the property and they win. They either meet the minimum bid or they go over, and they would maintain ownership at that point. The last option would be that the auction is in fact canceled. Now, this can happen for a variety of reasons. Most typically, it happens when a property owner comes to what's called a permanent foreclosure prevention alternative. That usually comes in the form of a loan modification, a payoff, maybe a repayment plan, something that would put the property owner out of foreclosure permanently and get them back into normal servicing. Now, after either one of these 4 options is actually reached, normally the notice of default, well, if the sale is postponed or if it's canceled, a rescission of a notice of default would be recorded, meaning the property is no longer in default. The loan is no longer in jeopardy of foreclosing against the property, and the loan is back to normal servicing. If the property is sold to the bank or is sold to a third party, a third document called the trustee's deed upon sale is going to be recorded with the county recorder's office. Now, this document is important because it actually officially transfers ownership of that property over to the winning bidder. Like mentioned before, by default, this is going to be the lender if no other bid higher than the lender's opening bid is actually received. Next slide. So really quick, we're going to go through a sort of a cookie cutter example of a few of these documents, as I had mentioned before. The first one being a notice of default. This document in California is required to be recorded with the county recorder's office, which has jurisdiction over the property or where the property is located. The notice of default is going to have a few pieces of information that are extremely important, especially when a property owner does face foreclosure. Most importantly, it's going to have the loan amount that is due at the time that this document is recorded. It's going to have the property address and the borrower's name. Okay. As we move forward, I do want to stress that this is where a lot of the misinformation can be created, because it's important to understand that there are going to be other I guess you could say businesses or services that are going to attempt to solicit their business to property owners that are in distress. Okay, so the first thing we want to look at here, the notice of default, again, has the borrower's name, the borrower's address, and the defaulted amount at the time the notice is recorded. Next slide. Now, as mentioned before, 90 days from the time that the notice of default is recorded, if nothing is done, the notice of trustee sale is going to be recorded. Now, with the addition of, adding on top of originally the borrower's name, the property address, and the loan amount that was due at the time of the default, like the notice of default document, now we're going to have an additional 2 pieces of information. The notice of trustee sale is going to have what's called the opening bid, or the minimum bid. And that number is going to be the amount of money that's due to close the loan out for sure. Okay. Additionally, it's going to have a date, a place, and a time of the auction so the lender can come current on their loan. This additionally is another important piece of information because it needs to be understood that if the property owner is in foreclosure and they are receiving information, this information is made public, and there's going to be a lot of individuals who understand, or a lot of organizations who understand exactly the status of the loan and where the property owner sort of lands. Next slide, please. Now, this is another copy of a document called a trustee's deed upon sale. If unfortunately the property owner is unable to meet the obligations of their loan and they go through the notice of default and they do go through the notice of trustee sale and they do reach the sale date and the property does sell, this document will be recorded next. Now, what's important about this document is that not only will it tell who the new owner is, whether it be an organization, an individual, it's also going to say how much the property did sell for. And this can be very important when the property, if for whatever reason is sold for maybe a small amount of money and it goes over the minimum bid. Now, what we will talk about in a couple of minutes is the idea of excess proceeds. Now, any amount of money that is, sort of earned through the trustee's sale that is over what the lender is actually owed is going to be actually owed to the property owner or the person who should have the rights to the property. Next slide. Now, getting to this portion is always a little bit difficult for people to sort of look at and understand, but it is a true and harsh reality. Once a property does foreclose, if the property is occupied by the previous owner, the only notice to vacate that's required to be given by the new owner is 3 days. A property owner is owed 3 days in written form to vacate. Now, a tenant may potentially receive a longer time before the eviction is actually, sort of filed up. And during this time, it's important that certain notices are recognized. And when an individual is served with one of these notices, most likely the notice of an unlawful detainer, that they pay very careful attention to it. One, because ignoring these notices can sort of advance the process and move it down the line a lot further than normally. The other idea is that you want to make sure that the notice is being served by the proper party. Now, in both situations, whether it's a tenant or an owner, this is normally the time where a cash for keys negotiation would begin. Now, cash for keys is just sort of the industry standard or the industry phrase for occupants of a property negotiating the terms of them vacating that property, moving forward. Whether or not there's an unlawful detainer or an official legal eviction, that would be the time when this negotiation would take place. It could be a situation where somebody says, listen, I don't have too much money. If you'd be willing to give me, X amount of dollars, I can pick up all of my things now. I can pick up all of my things now, and I could leave the property and, have more of a graceful exit. The new owner may be inclined to do so to avoid either a harsh legal battle or something like that. It could be the situation where somebody says, I have enough money, I just need time, or or I don't have anywhere to go, I need money, whatever it might be. This is just open. It's not something that's legally required. It is something that does happen, again, because both parties sort of understand that they have something to lose or to benefit from engaging in these conversations. Next slide. Now, going back really quick, I know we didn't mention what excess proceeds or the idea around that, or what that really is. When a trustee's deed upon sale is recorded, it is going to show a couple of pieces of information. Most importantly, it's going to show the amount that was in fact owed, or what's more typically called the minimum bid against the property to clear the lien. But it's also going to show what the amount of money that the property was sold for. Now, that the difference between those two amounts is going to come in the form of what's called excess proceeds. Now, if an individual did own a property and maybe they had no heirs, or maybe they had it in a trust, or whatever it might be, they're going to be required to contact what's called the trustee who held the sale and let them know that they're interested in claiming the excess proceeds. Additionally, what that document is going to show is the date when the property did sell. It's going to have information, contact information, more accurately, for the trustee. And it's going to have normally it's going to have how an individual should contact the trustee and what documentation they're going to need to fill out when that document is recorded in order to claim the excess proceeds. Next slide. Now, I did want to jump in a little bit to the types of liens that can foreclose, and then also priority when it does come to foreclosing liens. Most typically, you're going to have liens that are purchase money loans. So if an individual wants to buy a property, they go to a lender and they say, hey, I wanted to buy this property based on my credit. They apply and they get a loan. It's going to be called a purchase money loan. Reverse mortgages are something that are loans that are only allocated to senior citizens over, I believe, the age of 62 and a half. A home equity line of credit would typically be a second lien. It's going to come after the purchase money lien. It can be in the form of a first lien, just depending on what is actually against the property at the time. There are such thing as property tax liens that a county can levy against the property should the property owner fail to meet their obligation to pay their annual property taxes. There are judgments that can turn into foreclosable liens. Now, if an individual is sued and the judge decides that the judgment is going to be put against the property with the power to sell, that could be another lien that could foreclose. And then also, it's important to understand too that homeowners associations can also foreclose against properties. Going back, I really just want to stress as much as I can that there is a lot of misinformation out there. Every one of these liens, if given the proper authority, can foreclose despite their position. I've heard a lot of individuals tell me that they have a second lien or they have a homeowners association and they're threatening to foreclose, but they feel very strongly that they do not have the ability to foreclose against their property because maybe they're current with their first loan. Unfortunately, that is not the case. If a home equity line of credit or a second lien or a homeowners association decides that you have failed to meet your obligation, they can go after the property. Okay. Now, moving over a little bit into lien position, the lien position doesn't necessarily affect a lien's ability to foreclose. What it does affect is what's called survivability. So if I have a purchase money loan I bought my property, let's say 10 years ago, and then 2 years ago, I took out a home equity line of credit and I said, you know what, I need to remodel my kitchen, or I need to, maybe put my kids through college or something. The lien that would be in first position would be the first one that came when it comes to time. So that would be the purchase money loan. The second lien or the next lien that would be in the second position would be just, like I mentioned, the home equity line of credit or a HELOC. Now, when it comes to survivability, if I fail to meet the obligations of the second loan or the home equity line of credit, the first loan would still have the opportunity to foreclose, and it would be on the following borrower or the following owner. Now, if for whatever reason I failed to meet the obligations of the first loan, that first loan, in fact, would foreclose. Well, if they did foreclose, they'd foreclose. And the second lien would lose their right to collect against the collateral, meaning they would not have the opportunity to foreclose against that property. Another thing to be considerate of is what's called the right of redemption. And we're sort of jumping into another little topic here. A homeowners association is going to foreclose against a property with one caveat that's very unique when it comes to foreclosing in California. They're going to foreclose with what's called a 90-day right of redemption. Now, a homeowners association will sell a property for as little as $1,800 in past due assessments, and they will foreclose with what's called, like I mentioned before, the 90-day right of redemption. This gives a property owner the opportunity within 90 days to pay up everything that they owe in order to get title to the property back. Now, when I mentioned here superior liens, that is something that is to be thought of. If an individual is foreclosed on by their homeowners association, that does not mean that the other liens will go away. So essentially a lien above the first or the first or the second lien, so those liens will in fact survive. So it is important to understand that just because a homeowners association sells a property at foreclosure, that that it's going to wipe out or clear out any other liens against the property. Next slide. Now, a lot of individuals are going to say, hey, well, how do I know if I'm going to be in foreclosure? How do I know if my property is there? What if my lender doesn't communicate with me? Well, in the County of Los Angeles, the homeowner notification program was established in 1996 in order to alert homeowners of newly recorded documents. Now, the documents that are required to be mailed out to these property owners and to the property addresses are grant deeds, quitclaim deeds, and deeds of trust. Now, a grant deed and a quitclaim deed are going to be the two main documents that are going to transfer title of a property over to a different individual or an organization. A deed of trust is going to be used when a loan is taken out against a property. Now, the law actually requires that a notice of recordation be mailed out to the party or the parties within 30 days of the recording of one of those documents. The document also comes with information and counseling and assistance provided by our department, to just within the envelope. Next slide. Now, the enhanced homeowner notification program was brought about with Senate Bill 62, and it expanded the homeowner notification program to not only include grant deeds and quitclaim deeds and deeds of trust, but to also include the main foreclosing documents that are used, like the notice of default and the notice of trustee sale. Senate Bill 827 actually reduced the time to mail these notices down from 20 days to 14 days. And the bill was actually, or the service was expanded for an additional 10 years by Assembly Bill 1106. Next slide. So why is this important? If an individual does face foreclosure and they are looking for advice, help, things like tips, support, or guidance, it's important to make sure, like I had mentioned before, that you get the information from the right organization. Good information is not only hard to come by, but it can be hard to sort of tell the good from the bad at times. Now, the Department of Consumer and Business Affairs does have a foreclosure prevention unit. Now, our unit is designed to help owners navigate the foreclosure process and explore any and all options that might be available to them to avoid foreclosure. It is sort of important to understand that avoiding foreclosure doesn't always mean keeping or sustaining ownership of the property. But our unit is built to basically open a dialogue between property owners and their lenders in order to ensure a property owner is reviewed for assistance correctly. When these reviews for assistance do get submitted to owners, this comes in the form of an application, which is commonly misunderstood. Individuals believe that because they own the property that they're owed assistance. When a property owner does fall behind, they are required to apply for assistance. It doesn't automatically guarantee them help. Now, our department does provide guidance and a piece of understanding if an application is submitted to a lender and the lender does come back with options not necessarily options, but with answers to their application. The benefit of working with our department is an individual will receive attention from the beginning of the time that they open the file to the end, whether that be the foreclosure of the property or whether that be, maintaining assistance maintaining ownership and understanding the assistance that they've been offered by the lender. Next slide. Now, a couple of things I wanted to just mention here. It is important now, just because of the times that we are in, to understand that there are, pretty uniquely, programs that are given actual relief to owners in the form of financial relief. The very first one is going to be provided by the Los Angeles County Mortgage Relief Program. This program is currently being administered by Neighborhood Services LA County. The website is listed there as nhslacounty.org/mortgage relief program. They can be contacted directly by phone at 888-895-2647. Now, the program actually requires that the property must be owner occupied. It can be a 2 to 4 unit property. There can be as many as 4 units against the property as long as it's occupied, and has to be located in the county of Los Angeles. Now, the next mortgage relief resource that I wanted to talk about would be the California COVID-19 Rent Relief Program. Now, that is currently being administered by the state, and it can actually be applied for by a renter or a landlord. So if you're a renter who can't pay their bills and maybe the property is falling into foreclosure, or maybe you're a property owner who can't pay their bills because the property is falling into foreclosure because the renter's not paying, you can apply directly online at housing.ca.gov, or you can call them directly, either a renter or a landlord, at 833-430-2122. Now, most recently, the California Mortgage Relief Fund opened up. And this mortgage relief fund was aimed at homeowners or property owners of single-family owner-occupied homes. This program does have the ability to provide individuals with up to $80,000 in forgivable funds in order to catch them up. Property owners are actually encouraged to file electronically online at CAL, so California, HFA.ca.gov/HAF/HTM. Now, if you figured out that, maybe you didn't have the ability to apply online, they are encouraged to phone in at 800-569-4287. Now, these 3 resources originally, they're the only ones, or the only legitimate resources that are providing financial help to residents of either California or the county of Los Angeles. If a property owner fails to meet any of the requirements of any of these programs and is disqualified for assistance, it's strongly encouraged that these property owners contact our department directly. The County of Los Angeles Foreclosure Prevention Program within the Department of Consumer and Business Affairs can be contacted directly by phone at the number mentioned below at 800-593-8222. And additional resources can be found online at our website, dcba.lacounty.gov. Next slide. Going back really quick, I did want to mention that, it's going to be important that, when somebody goes into this situation of foreclosure, that there's a lot of bad information that goes out. Like mentioned before, the notice of default, the notice of trustee sale, the trustee's deed upon sale, those documents are all public record. So it's going to be important to understand that if you are in that situation, that those documents are available to anybody who's willing to pay for them. These property owners are going to be vulnerable to deceptive individuals or organizations willing to solicit their services, who are going to make promises such as, they can absolutely save a property from foreclosure, or they can, for a fee, help somebody collect on the excess proceeds, like mentioned before. It's important to understand where to get good information from whenever you're in a bad situation. I would hope that nobody ever finds themselves in that situation, but if they do, our number, our telephone number, our services are free, and they're open to the public. You will see from time to time, if you are a property owner, maybe you just pay attention to the radio, but even TV, radios, billboards are gonna offer services about getting a loan to save yourself from foreclosure. And they'll say things like, you don't even need a credit check, or we'll come to your aid and we can promise the world. Just be very careful and understand that while not all of these institutions or these organizations are are scam artists or things like that. A lot of times with certain things, sometimes when it's too good to be true or it sounds too good to be true, it probably is. Next slide. Okay, so that sort of wraps up our presentation for today. Do we have any questions? Kevin, I haven't seen if anything was entered into the chat. No questions. Okay. We can kind of wait a minute or two to see if somebody decides to think of anything. Okay. All right. Well, if that's the end of the webinar, Kevin, thank you for your time, your help. Everybody, thank you for attending. If you have any questions, our telephone number was listed, in a couple of previous slides, or, if you'd like to give us a call, absolutely give us a call, and, we can discuss the personal situation you may have. Oh, it looks like we might have one question. Let's see.
Okay, Sam, one of our attendees asked the question, if your property has equity, can you suggest for the owner to sell?
Well, okay, so I can't suggest anything, but that's a great question. And the reason why I can't suggest anything is because that goes into the realm of legal advice. But what I can offer is the idea that if the property does have equity, what do you stand to lose here? If you were to look at this as just merely a financial investment, you stand to lose the equity if you decide to let the property go to foreclosure. Does selling it make a better option? Maybe. If it's, and it probably makes a better option if you don't have the ability to even come current on the loan. Life happens sometimes. People lose their jobs, they lose employment, and they have no way to pay this money back that they use or that they borrowed to pay the to pay the loan off. Does it make more sense to sort of sell the property and make as much money as possible financially? Probably. If an individual, again, and this is why I always tell people to give us a call, directly, because every situation is different. If somebody, for whatever reason, loses employment temporarily, and then, or maybe they have sporadic employment, maybe they can't pay their bills for a month or two, and then they get their job back, and they apply for mortgage assistance, and the lender approves them. That's a different situation. So I would say that, if somebody does have a property and they feel like they're in danger of losing it, for whatever reason, give us a call. Let's sort of hash out the details before we sort of make any suggestions or go over any options. Okay, hold on. Kevin, so it looks like, was there another question in the chat?
Yeah, so as a follow-up to that conversation, one viewer asks if mentioning they keep getting offers from cash buyers. Is there a way that you could know if they're legitimate, and should those be entertained?
Oh, well, I mean, I guess it would it would probably depend on when you say cash offers, is somebody coming with a bag of money to your house and asking you to sign it over? Are they looking to go through a real estate agent with a cash offer with certified funds or verifiable funds? The Department of Real Estate does have licensed real estate agents for a reason. Sure, you could entertain it. Does that make it the best idea because you see the money? I don't know. I don't know for sure. But if you can verify that these funds do exist and they are willing to sign a contract to saying that they want to buy the property, that would be up to you. Again, that goes into the realm of legal advice. I can't necessarily tell you if it's a great idea or if it's not a good idea. But what I can do is try to make sure that you understand, how this can sort of turn out.
All right, Sam, I think that's all the questions we have.
Great. All right. Well, thank you, Kevin. I guess if that's it, then I think we're good to go for the day.
All right, thank you everyone for joining. Our recording will be available on our website at dcba.lacounty.gov. Have a great day.
Thank you, Kevin.